That's honestly what you're supposed to do. You're supposed to end up even if all goes right. Just do it. I never do it.
How you doing? Saw you this morning.
Where?
Okay.
Not me this time.
I'm sure.
Is the county attorney going to be here?
Well,
I will. Yeah, I mean, the one on this case. Yeah.
So we all had this discussion in December. Have you read all the Supreme Court ruling, all the stuff from the news camera?
Oh, yeah.
Essentially, first thing is they decided when they got to this thing. Oh, no, yeah. And yeah, and he's got well, it's been easy.
Yeah, I do too. Thank you.
Oh, sure. So I agree.
I'll just give it a real quick.
That's what I was trying to get to. They've already gone.
This is right.
And then I can talk about further child. He's coming back.
No, no. I haven't seen anything.
If we go.
Yeah.
Oh, yeah.
Call the meeting of the Madison County Board of Zoning Appeals to order, please. Gentlemen, you received a copy of last meeting's minutes. Are there any additions or corrections?
I move to be approved as submitted.
Do I hear a second? Okay. Suzanne, would you read the agenda for tonight, please?
Bill? The applicants, petitioners, William Rother, Belmont Farms LLC, are appealing the county planning zoning administrator's December 11, 2020 determination letter related to special use permit application case number SU-11-20-21 CWSX LLC.
Thank you, Suzanne.
You're welcome.
With representative or?
Sorry if I go real quick,
Yeah, please.
Chair, and then then we'll let the representative, the applicant. I'll just be real quick, just to be clear what this hearing is and what it's not. And I think people see things, see the ad, and maybe a little confused. This is not an appeal of the decision that the Board of Supervisors made on November 4th. This is simply again, as we sort of had back at our work session, a continuation of the discussion of the completeness of the application that we received on September 3rd. I've got the letter. You've seen the back and forth letters, the volleys back and forth. My response, specifically in this, the December 11th response, and I'll just be very clear. This is not my decision that it was complete. We've received the application. The state code has very specific regulations regarding to applications of cellular towers. We have that deemed complete after 10 business days. That's it. It's as simple as that. So I'll sit down. Okay.
Good evening. My name is Roy Shannon. I'm here on behalf of the petitioners. As you know, we were here back in December. It involved whether or not those two previous appeals were actually appeals, and determined that they weren't. This was a proper appeal. In this instance, we filed a request for determination as it's laid out in our appeal in the materials that you should have reviewed already, that clearly identified our concerns on behalf of my clients. My clients are adjacent property owners next to where the cell tower will be located. When that application was filed, they went ahead. At this point in time, October 22nd, 2020, we asked for just some determinations that, is this a complete application? I'm not sure if you've seen the application. I have it here in the binder. They had a number of things here. And is this a complete application is what we were asking for. We received a determination on that one item. We've subsequently received other determinations that we asked about. But part of the importance of whether or not these applications are complete is so that the governing bodies had the full picture, and that's just not rubber stamped and pushed through. So when you look at his determination, that is Mr. Webb, as his job as the county planner, he stated that, yes, the application is complete and has been deemed completed as of September 18th, 2020. I'm not concerned about whether it's deemed completed by the state code or things like that. I mean, personally, I don't think it is an issue here before this board, whether or not it's deemed completed. I'm asking the zoning director, whose job it is to interpret the zoning ordinance, if it is a complete application. If nothing happens and he doesn't do anything for 11 days, fine, the state code might say, well, then it's deemed complete. That's the state code doing that. As a zoning administrator that processes these applications, he gets to interpret the zoning ordinance. You, as the Citizen Oversight Board, get to make sure that he's doing his job. And I'm not attacking Mr. Webb, but the fact of the matter is, when I looked at that application, there was various parts that were missing that just weren't done. And so the idea that when he said it's complete, we disagree. He made that determination. Within the 30 days, we appealed and said, no, we think it was incomplete, that the information is not in here. And that's the simple thing. And that's why one of the items I requested in the supplement to the appeal that I submitted on Friday was indicating, do you guys have the complete application? Because that's the issue. He says it's complete. We say, no, it's not complete. We want the Board of Zoning Appeals that oversees the zoning ordinance to make that determination, to look at the application and say, yeah, this isn't complete. Whether it's deemed complete for purposes of the state code and going forward, that's not the issue before the BZA today. The question is, this application, the zoning administrator felt was complete. We could go through and identify the deficiencies and where we think that it's not complete, that there's things that are missing. And this is, it's critical because, as you guys know, the zoning ordinance with 14.3 for these cell towers, the goal of it is to limit the amount of them that are all across the county, to reduce the size, hide them. They actually have in 14-13-5 of the zoning ordinance, it has a hierarchy of what you're supposed to have. In terms of, you could have the attached cell towers or the wireless communication facilities. 2, you can have it co-located or combined with an existing. 3, mitigation of an existing one. 4, concealed or freestanding. And then the 5th one, non-concealed WCF. That's what we have. We have a non-concealed tower. This is the worst case scenario for the situation under the zoning ordinance. They don't like these. I mean, they're out there in the open, and so no one does like them. And when you go through the 14-13, you will see all the various things that are supposed to be considered. Well, they're only going to be considered if they're in that application. So if the application isn't complete and the zoning administrator or staff doesn't check, then when it gets passed on up, it's an incomplete package. It's not everything that's supposed to be there. And all that we're insisting on or wanting to occur is that if they're doing their job, all this information is there. So for example, 14-1310, the submission requirements, an affidavit of the radio frequency engineer certified compliance with the alternatives hierarchy set forth in section 14-13-5, okay? If a lower ranking alternative is proposed, the affidavit must provide specific factual information explaining why higher ranked options are not available, are technically feasible, practical, or justified. So we're at the number 5 level of this is the worst type of tower to have in Madison County. And there's no justification, explanation why all the other ones don't work or why the technical data is there. That one was just, in terms of being glossed over, that's number 1. Again, they have the evidence of ownership. They went ahead and put in that the applicant has the authority to do this. That's fine. But on the big ones, number 10, the radio frequency plot map, again, they're supposed to have a certification from the applicant's radio frequency engineer that the proposed facility's coverage or capacity potential cannot be achieved by any higher ranking alternative. So again, we have the worst case scenario, and they're supposed to provide these certifications and information saying why the other ones don't work. And that was never done. And when you look at the application, and I'm not sure if you guys have been provided the application, I believe you should have, since this is what we're asking you to weigh your opinion on. But when you look at the application, they actually have a list of alternative sites that they were considering. Maybe this is the 10th one. Now, one could say, well, they went through and they checked all these other ones. The excuses just aren't there when you look at the items, but that doesn't excuse the zoning administrator from saying this is a complete application if it's not. So in our package, we said, will you please forward along the application so that you, as a zoning board, the Citizen Oversight Board, can ensure the zoning administrator is doing their job. And again, I'm not attacking Mr. Webb personally, but here you have an application, and you could even tell them the determination. It says, well, it's deemed complete. That's not the question. The question isn't whether it's deemed complete. The question is that a complete application? Are these things that are being submitted complete? Or is this just a pass-through type requirement? And again, a lot of the emphasis on this is critical for adjacent property owners. So again, you look at 14-13-10, there actually is no A. it's B8. Cost of concealment technology that exceed facility development costs of the proposed wireless communication precinct, WCF, shall not be presumed to render the technology unsuitable. So even if it's more expensive to do one of the higher ones, then okay, do it. But again, the application lacked the critical information. And so it always refers back to that 14.13.5, which is the hierarchy standard. When you're at the lowest hierarchy, you're at the lowest one, the freestanding tower that we have here, a monopole, you have to justify why the other ones don't work. That wasn't done, and especially not to the level of detail that is required in these type of applications. So this is a real simple appeal. And, I saw their objections and their opposition to it, talking about the state code. The zoning administrator isn't tasked with interpreting the state code. The zoning administrator is tasked with interpreting the zoning ordinance. And the BZA is tasked with overseeing to make sure that's done proper. This is not a situation where we're citing case law to you and saying this is the way the state code should be read into this provision or that provision. It's real simple. Under the Madison County zoning ordinance, there's requirements for a complete application. Zoning administrator thinks it was complete. We disagree. We're asking, does the BZA think that this zoning application that was submitted, if it's complete? If you think that the work that was done here and what they provided was complete, then that's how you're going to rule. If not, then we have a motion that overrules the zoning administrator to the extent of saying, hey, look, that's not a complete application. Now, what that may have impact on other matters is not really of consequence to the BZA in this situation, because that's not, whether or not it matters at this point, it's too late, state code says this or that. That's not issue. The issue is whether or not it's a complete application and all the information is in there. So it is quite a simple appeal. But when you look at that 14.13, I'm sure you guys have reviewed it. The purpose is to encourage owners and operators of WCFs to locate and configure them in a way to minimize the adverse visual impact of the landscape and adjacent properties. It's one of the main requirements. In the hierarchy, we're at number 5, we're at the lowest one. So if you're going to go the lowest one, it should have the most justification on why number 1, 2, 3, and 4 don't work. And that just wasn't in here. Again, I would ask that if you haven't seen the application, that you defer making a decision until you actually review the application, so you can, for yourselves, determine as the Citizen Oversight Board, whether or not it was not deemed complete, whether it was complete or not. And again, there's a number of those items that when you go through, you can see it's just not there. The requirements for what they were supposed to provide were not laid out. Again, that's the job. And the idea that, well, it doesn't matter if you just wait 10 days, it's deemed complete anyways. That's not doing the job that you guys are tasked with overseeing. Is that the zoning administrator says, well, it doesn't matter. I just waited 12 days, so it's deemed complete. I don't have to check it. That's not the job. And again, the applications, as Madison County grows in population size, there's going to be more and more. And again, it's not a heavy ask to make sure that someone has the complete application before it gets processed and pushed through. In fact, and I'll end on this, I'll point out that even in the application process, the zoning administrator can ask for additional time and can bring in experts in case it is, and not saying that Mr. Webb isn't capable enough to go through this and identify all the various aspects, but he can actually bring in specialists. This is in 14-13.6 under the general requirements of the zoning ordinance. Under A4B, a supplemental review may address any and all following: the accuracy and completeness of the application and accompanying information. So the county reserves the right to go do an additional review and determine whether it actually satisfies it. So this can be done. It's built in to make sure it's complete. And we don't think it was. Mr. Webb thinks it was complete. We're asking the zoning board, the BZA, after reviewing the application that they submitted for this site plan, or for this special permit, is it complete? And that's what we're interested in finding out. If you agree with Mr. Webb, then you would move to affirm. If you disagree with him, then you would reverse his determination that it's complete. It ends there. I'm happy to answer any questions now, or reserve time at the end to answer any questions you may have. Chairman.
I don't have any. Yes, board can ask questions, certainly.
I have a question for you.
Sure.
Would you go through the process? I mean, it is, correct me if I'm wrong, but it's gone before the planning commission and the board of supervisors, correct?
Yes.
Did the board of supervisors have an issue with the completeness of the application?
Apologize.
I don't think they really talked a lot about the radio frequencies and all that. It was really the location of the tower.
Yeah.
150-page application that we received. So that was, really, they had a lot of information, to study.
So the way I understand, it, the board of
As I said,
supervisors
well, this is-
proceeded with it and took action on the application.
This is a very technical document, the application.
Yeah, I mean, and again,
Tough pages.
I understand.
no, I mean, and these submissions are supposed to be very significant because they're supposed to include a lot of detail. I mean, because putting a tower up on a ridge or down at, around people's property in the county and historic sites, it does matter. So, yeah, it was processed long, and the planning commission during the joint hearing, they approved that. What the board of supervisors considered themselves and what they valued in their head in making that decision, they're the elected officials. I have no idea what, Mr. Jackson and what they decided, what was the appropriate thing. In terms of this process of the BCA appeal, you're the non-elected but citizen oversight board of the one person, the zoning administrator. And you guys, when you look at that zoning ordinance, you're the ones that get to say that variance is okay. We're okay if you miss this rule because there's a hardship or something. But when we get to appeal, the determination, decision, order, or violation that's given it, and we appealed it, and that's why we're here. But yeah, in terms of what they consider, I don't know, sir.
I don't agree with your interpretation there.
Of which part?
I don't think we oversee him, we oversee the board of supervisors.
But I think the Board of Zoning Appeals is specifically tasked with overseeing the zoning ordinance, not the Board of Supervisors is the elected officials.
That's correct.
Right, so I think ultimately from here, when the BZA makes a decision, an applicant has the ability to appeal that to the circuit court, but not to the Board of Supervisors like that. So you do oversee, you can't overturn a Board of Supervisors vote, but you can overturn the director and say, no, director, you can't do those violations. That's not in accordance with our purview. Not the Board of Supervisors, different. So when you're sitting in this capacity, it's more judicial in nature. When you do this, the variance or those, that's more legislative. People are saying, hey, we need an exception because this hardship. When we appeal a decision of the director, you're sitting more like a court, and where you get to say, hey, wait a second, did this director do the right thing or not? And again, different BZAs do it differently. Than for BZAs that have overturned directors said, no, that we think that was wrong, and start again. And again, I appreciate the fact that Madison has the zoning administrator that wears multiple hats and supports the board, but that is what we're asking you today, is to determine whether or not that application, and that's why we asked for you guys to at least see the application. That's what the appeal is about. I mean, my request for determination was specifically on that issue, and that he responded about the special use 11-20-21. Again, I'm happy to conclude, come back here if you have any more questions on the matter.
Has the planning commission and the supervisors approved this? Is this correct?
Yes, they have approved it already.
Well, how can we go over top of them?
Well, you're not going over top of them. You're just, right now, before you, there's an appeal that says, we said, hey, is this a complete application? He said, yes. We say, no. This has nothing in terms of what they did, the elected bodies. If you say, we don't think that's a correct and a complete application, fine. That may be where it stops. But if you say, no, we think that was a complete application, because that's what the question that's being asked is it complete or not? You say, it's not complete. Okay. That's it. And we know that that is insufficient. And again, you know what, maybe next time, the next cell tower application that comes through, it's going to be looked at more carefully. They're going to say, hey, give us all the documents. Don't just give us the 2-page of this and a bunch of pictures and a large stack of things. Like, we want the real documents that say you can't put it anywhere else. You got to try harder, CWSX or where the applicant was, to say No, you gotta identify why you can't put it anywhere else. Why the one tower that's in that 3 can't have different equipment. Why this is necessary. Again, that hierarchy is very important. It's referred to multiple times throughout 14-13. So you're right, they've acted on it, and they've acted on it. So this isn't gonna overturn necessarily them. I will tell you that there's legal challenges to that, but right now is a real simple thing, is this application deemed complete, not deemed complete, is it complete the way it's drafted? That's why, if you haven't looked at it, I would ask that you defer any decision until you review the application, make your own findings, and look at this code, because the code does actually a very nice job of laying out the provisions of what you have to do, and it's under 14.1310, submission requirements. Number one, they didn't do. Number 6, they didn't do, and again, some of these are minor. Number 6, propose exterior paint and stain samples for the components to be painted or stained. Right, well, obviously that's not our big issue. The other issue though is 1 and 10 say, explain why the other ones didn't work. Explain why you can't do the tower these other ways. And that explanation was lacking. And that's one of the ones we really have the big issue with, is you didn't explain, you just went the easy route. The tower is there, not why it can't work in other places. So again, when you look at it, 14.13.10, it lays out submission requirements, and you look at what they submitted, and I don't think it's a complete application. And I think it's.
Felt like he was complaining, so they didn't see that. Felt like he was- They voted it.
But I mean, they voted to approve that. That doesn't mean that all that information was there. They may really wanted it.
I would imagine they would have the application.
Well, right, and so in terms of,
Voted that it, and agreed that it was complete, so.
well, I don't presume to know what the planning commissioner or supervisors knew when they were, making their decision. They may say, this is the greatest thing, so we want it. And whether it's complete or not, I don't know. And you can look back at it and say, well, if they think it's good enough, then it must be complete. But if it's just a rubber stamp process and it's not complete, well, then at some point, things are just going to be approved, and they didn't do their due diligence to make sure, what if this could be put up on a different location of property? And if it's, these other properties are better suited, they got to explain why there's no other choice when you're going to that bottom rung. And again, if you're relying on Mr. Webb here, this is your job where you can overturn it. The planning commission, they rely on staff, and staff is Mr. Webb, and he says, recommend approval after looking at it. The politicians rely on staff, that's fine. You can rely on staff for your support, but when we're saying we think the staff got it wrong, this is your job to say, no, Roy, Mr. Shannon, we think your clients, we think they're wrong. We think Mr. Webb, as the zoning director, made the correct determination. That's a complete application. Planning commissioners are relying on it. You don't forward it forward if it's not complete. So they're just assuming, hey, because it's before us, it has to be complete. And this is an opportunity for this, again, I keep on saying the citizen oversight board, because you're the oversight. You're the one. So in this case, you can rely on Mr. Webb and say, yeah, it's a complete application. And I want you to actually just look at the application. I think the application should be before you right now. I think it was part of the appeal of what we had challenged. So I don't know how you determine if it's complete or not if you haven't looked at it yourselves. So that would be the piece of evidence that I would put forward, and the county controls it, is when you look at that complete application, is it complete? That's why I asked in that last supplement, because I didn't see it in the staff report, that I specifically requested that he's failed to report the complete record. And we want the staff report for this upcoming hearing doesn't include the SUP application. BCA cannot properly assess this issue before it on petitioner's appeal without being able to review it. The only way that you could say it's a complete application without looking at it is we're just relying on him and not doing it. And we're asking you to look at this application and determine if you think it's complete. You're right, it doesn't, in terms of the planning commission, that they've made their decision. But they're relying on staff. I'm happy to answer more questions later on. I know the public gets to speak at these hearings, so maybe that'll jog some additional questions for your service.
Thank you.
Thank you, appreciate your time.
Yes, sir.
Mr. Chairman, members of the BZA, I'm Pat Taves, and I'm here on behalf of Mr. Webb. This is my second time appearing before the BZA. It's my pleasure to be here again. First time was on December 22nd. I think you all probably recall that. And at that time, this board acted on appeals, 2 appeals that same person, Mr. Rother and his company, filed with the Board of Zoning Appeals. I don't know if you recall, but the same exact issue was before the BZA at that time. They had filed 2 appeals, both of which they claimed those decisions that Mr. Webb had made were determinations that the application was complete. And so they filed these 2 appeals. One was to a notice, the notice of the public hearing. The other was to the staff report. This board denied those appeals and decided that it was deemed complete. The application was deemed complete. Now, what's interesting to note about Mr. Shannon's argument is that what he's telling you is ignore what the law is, that state code provision. Ignore that and follow the zoning ordinance. Well, let me give you a little background on this. The state code is what controls the law in Virginia. The zoning ordinance is adopted in compliance with the state code. If the zoning ordinance is not in compliance with the state code, that zoning ordinance is illegal. So what we have here, and you all have in your packets, Exhibit 3. You could please turn to Exhibit 3. That was the provision that I relied on when I appeared before y'all back in December, on December 22nd. Paragraph C1 is the critical provision. As you can see, it says that if the applicant is not given a notice of incompleteness within 10 business days of an application being filed, then the application is deemed complete. Those are powerful words in the law. What that means is it doesn't matter what you think, doesn't matter what Mr. Webb thinks, it doesn't matter what Mr. Shannon thinks, it doesn't matter what anybody thinks. If it's deemed complete, it is deemed complete. So that's why you don't need to look at any application today, because it's deemed complete by the law as a matter of law. And just to show you another part of the same statute, I'd invite your attention down to paragraph 2, right below the C1 that I mentioned. Paragraph 2 gives some deadlines for the county to act on these types of applications. These provisions apply to cellular facilities, okay? So if you look at paragraph 2, county's got 150 days to act on the first type in paragraph A, and 90 days, the lesser of 90 days, or whatever is provided by federal law for the second type. And guess what happens if the if the county doesn't act within those deadlines? Please go down to paragraph D. That's even more powerful than deemed complete. That's deemed approved. Now, once it's deemed complete, let's go back to the completeness. Once it is deemed complete, it means it's complete. This body can't overturn the state law. Mr. Webb can't overturn the state law. That's the state law. So it's deemed complete, and you can see from Mr. Webb's decision, his determination, that was complete. That was completely accurate. The state code, the only critical fact involved here is whether any notice of incompleteness was submitted to the applicant. And here, the decision says no notice of incompleteness was submitted. You haven't heard Mr. Shannon claim that there's a notice of incompleteness that Mr. Webb ignored. There isn't. So what that means is, under state law, it is deemed complete. Now, Mr. Shannon mentioned a hierarchy. The hierarchy is this: state code, zoning ordinance. If the zoning ordinance is not in compliance with the state code, then the zoning ordinance fails. We have to comply with the state code. Can't violate the state code. Council said he's not concerned about the state code. He's not concerned about whether it's deemed complete. Once that door shuts on September 18th, that issue is decided. And this board decided the same exact thing. You remember I gave you all I suggested to you some motions. And in fact, that reminds me, I've drafted some motions for you tonight. And if I could hand those out to you. And I apologize, Mr. Lillard, I was not aware that we had a new member. So I didn't have your name in here, but we can.
That's okay. It was my mistake not being here in December. Nobody to blame but myself.
But if the board passes this motion, which I would recommend because it's correct, then we can certainly put your name in there. As you can see, the motion that I've proposed is very simple. It basically says it was deemed complete. There was no notice of incompleteness. And there's been no change in the law. There's been no change in the facts. In fact, well before December 22nd, as you all have noted, the Board of Supervisors approved this application. So it was certainly complete insofar as they were concerned also. That is exactly the issue. The council said that is not the issue before the BZA, whether or not it's deemed complete. Yes, it is, because deemed complete means it's complete. No ifs, ands, or buts. He said it was real simple. I agree. It is real simple. That motion does it. The facts have not changed. The law has not changed. This is a correct interpretation, as you can see from Mr. Webb's decision, and I'd ask that the BZA deny this appeal. Thank you very much. I'd be glad to answer any questions if you all have any.
Any questions from the board? Yeah, I got one.
Okay?
All right. I'm not in the dark on this. I read the paper, I watch for all these things. I try to come to a lot of meetings, try to give a little input on things. And sometimes things don't really work good for the people I question. And sometimes it runs downhill on me. But the question I have right here is, and y'all, somebody has to help me out here a little bit. This was approved on September 18th, right? I don't care who answers it.
September 18th is the 11th business day after September 3rd. So when September 18th rolled around, then it had been more than 10 business days since the application was filed. So by law, it was deemed complete as of that date.
These people applied on the 3rd, and you sent out notices to landowners about this cell tower, true? Okay. Here's the question. How many people here was at the meeting on September the 18th?
Would have been November 4th. The 18th is when it was deemed complete. The letter went out in October, 2 weeks before the hearing, which was November 4th.
Right.
So that's when people were notified.
Okay, so how many people were at this meeting to oppose the cell tower? That's sitting in the audience.
The November 4th meeting was the joint meeting.
On the board of supervisors?
Yeah, how many people, okay, did you oppose this cell tower?
I'm sorry?
Did you oppose the cell
yes.
tower
Yes,
to the supervisor?
yes.
I wasn't at the meeting, so what did they tell you?
When I opposed it, what,
What was their response?
they didn't respond to my objections.
They approved the application.
Right, I know they approved it, but I mean, what did they say when you objected to the cell tower?
I don't know, they had the reasons.
So they didn't, I mean,
That,
yeah, I don't care who answers
They talked
questions.
about the need for emergency services, the lack of in the area, that they thought it was dangerous. I think we had someone from, Mr. Emergency Service was there to talk about the danger they thought it imposed. So they were, obviously, the applicants weren't happy where it was, it's across the street from them, but I think there were plenty of people there that were supportive of it, and there were a few people who were against it.
Right, I mean, I understand. I mean, I was just asking.
Sure.
So, I mean, if they approved it, I mean, I don't see where anything can happen. I mean, I don't know, it's just, I mean, could somebody have stopped this at the supervisor meeting that night?
I guess what I'll say is, if they're saying that it's not, Mr. Tate said, it's incomplete. So we moved forward with the public hearing, we had a very comprehensive application. I guess what the applicant's saying is, if it's not incomplete, because a few things were missing, then it's still unreliable, it should never happen. But that's not what the state law says.
Well, I understand.
Right.
I just want to know how many people was at
But
the meeting.
there was a planning commission meeting, a joint meeting, public was heard, notified, it was in the paper, beforehand.
Right, I read the
Right.
paper,
So-
everything. I mean, I know. And I thought it was a good thing, was getting a sale tax.
Sure.
I really did. I mean, I wish somebody would come to me and want to put one on me. But then that's the only question I had.
anything else?
I have a question
Yes,
for you.
sir.
And I'm going back a ways here to the clothing optional campground back in the 80s,
Okay,
where there was a legal challenge. And I do remember, that was when I first went on the planning commission. I do remember that the first thing that happened was that the court sided with the applicant because the original special use permit was approved by the planning commission. At that time, the planning commission approved special use permits and it didn't go to the board of supervisors. And the courts ruled that an elected official or court-appointed official had to make the judgment. That a person that was not elected or appointed by a judge could not make the official opinion.
on a special use permit
This
application.
was on a special
Okay.
use permit application, but, over the years, I know Mr. Shackelford interpreted that to mean pretty much any decision, had to be done by the elected official. So even though Mr. Webb is an employee of the county, though, he's not an elected official. So what's the board of supervisors acts on it? Doesn't that supersede Mr. Webb's actions?
Well, first of all, it's almost apples and oranges here. So Mr. Webb is authorized as an administrative official in the zoning administrator
Right,
to render administrative determinations. Now, the Board of Supervisors, when it's acting on an application for a special use permit application, it's acting legislatively.
correct.
Here, Mr. Webb is acting administratively, okay? And so the board can't, the board acts in conformance with the ordinance. The board has vast discretion with respect to special use permit applications because
Sure.
it's acting legislatively.
Sure.
Now, whatever the law was back in the 1980s about this, the clothing optional special use permit, that isn't the law today.
Right,
The law today is that either the Board of Supervisors can retain the authority to grant special use permit applications. Or for some, it can retain all the authority, or it can give some of that authority to the Board of Zoning Appeals. And in this case, the board has retained the authority to issue special use permit applications. So it's acting legislatively on those applications. This board does not, to my knowledge, grant special use permit applications.
No.
You're here to simply review the administrative decision, whatever administrative decisions that might get appealed to the BZA. Now here, it's a very, very simple issue because the state law has made that decision without, and it's not something that Mr. Webb can overturn. It's not something you can overturn. It's pretty clear. Rarely have I ever seen an issue that is as clear as this one. Right there in black and white. Any other questions?
So you're saying the BZA has the authority to review any administrative issues that might be appealed?
Any administrative determinations?
And I'll give you an example, was that plat that we looked at
Yes.
last month.
Yeah,
That doesn't go for the board, that's administrative, and we denied it because it was deficient in acreage. So the appeal from there would be, because it's administrative, would be to the board of zoning appeals, not to the.
yeah, oh, I understand that. That was pretty
So that's just
specific.
kind of a good example of administrative.
Yeah, well, that was pretty specific.
Right.
3 acres, or it's not 3
This
acres.
is an administrative decision saying that it wasn't complete, that's where I made an error administratively from the get-go. Again, deemed complete.
I understand.
Mr. Lillard,
Yeah.
let me also explain one additional thing. We haven't gotten into all of the details from the December 22nd hearing that we had here. But what the applicant did, Mr. Rother and his company, they tried to appeal a public notice claiming that it was a determination of completeness, right? Yeah.
Right,
And
understand.
there was not one word in that public notice about whether or not the application was complete. Then they tried, a month later, they tried to appeal the staff report that had been issued before the Board of Supervisors acted on the application. Not one word in the staff report about completeness. The reason was because those weren't determinations of completeness. The determination of completeness was a month before by state law.
I understand.
Thank you all very much.
Thank you for that. I appreciate it.
Proposed cell tower. I'll let the attorneys argue the legal reasons why we are all here. But I just want to demonstrate, as a fellow Madison County neighbor, why I am here. I am not arguing that cell signals and broadband needs to be improved in our county. This is not why I'm doing this. Even though signal at my property is excellent. But when a DC tower company wants to set up a new tower in our county, this board, the Building and Zoning Planning Board, and the Board of Supervisors are the last line of defense to protect the residents of our community and to ensure that the application gets done correctly. Now, a year ago, after I had this picture made up, after the balloon test went up in the air, I hired a photographer to capture the red balloon. And then I created this picture, and I showed this at the vote at the Board of Supervisors meeting, and how the tower is going to look to us and to our property. Now, this tower, at the time when I made this, the tower was going to be a lattice tower at 199 feet. They did make modifications to it. They did lower it 10%, and they made it a monopole. Those are improvements, but it's still going to impact us greatly in our view shed. This is the reason why I bought this property 4 years ago. This is why I moved here. I'm also going to show you I wrote some things on this picture too. On the right-hand side, that side, there is a tower there. Now, from the perspective where the picture was taken, trees are blocking it. But there is a cell tower there that is on the south end of Orange. Now, that tower is quite a ways away. It's about 5 miles away. On the left-hand side, there is another tower that's out of that picture, and that's in downtown Orange. Both of those towers I can see during the day with the red blinking lights at night. Now, the other issue that I just figured out just a month ago, in the middle of that is the tower at Mount Pillar, the one that's covered that you can see on 20 behind the barn, that's covered in pine branches. I didn't realize I had a view to that. It's very hard to tell in there. So I had taken some other pictures and I zoomed in on it.
I have some other pictures here that I'd like to hand to you.
So you could see that. And on page 2 is the actual tower, a close-up of the actual tower. Now what we're arguing too is that proper studies, can you pass that? Can you pass those down?
Oh, good.
Thank you. Proper studies were not done in this application to ensure that this tower couldn't be used or improved to serve our area. This is only 3 miles away from the proposed tower in the same line of sight. Now, if the tower is to be built, Mr. Randy Ham and I have been arguing that moving the proposed tower to the north end of the Willis property, if you look at the last 2 pages, I printed out a plat survey and a satellite image of the property. If it got moved to the north end of that property, it's not that far away, it would benefit everybody. It would remove it from the view shed, be more concealed with natural trees, be near existing transmission lines, be on higher ground, which the tower company could save money by reducing the height of the tower, but it would still be at the same or even a higher elevation of the proposed tower. This would also better serve Madison County residents closer to Uno and Rochelle. It will still serve the intersection of 20 and 231, which is the tower company's goal. And it would remove it from the Madison Barber Historic District Zone. It's a win for all. It's a shame that this wasn't considered or even discussed. Please consider our pleas and arguments that this tower not be built at the proposed location and that the application be deemed incomplete. There are better options for everyone concerned. Thank you.
Anyone else in the audience?
Hello, I'm Sarah Fisher from UNO. And I want to know if you remember a sitcom from the 60s called Green Acres. Oliver was an attorney from New York. He wanted to be a gentleman farmer, so he moved out to the country to a place called Hooterville. When he moved there, he was missing one thing. A lot of things really, but one important thing was communication back to New York. So he had a lot of difficulty, but he got a phone. It was put on top of a telephone pole. And to access that, he had to climb the pole. So today, that story is still sort of appropriate because some people have to stand in the middle of their living room in a certain spot to get reception. Or we have people, and you know, will stop in our driveway to get reception. So having cell coverage is important for business, it's important for emergencies, and it's important for education. You can have a farmer that's in his field and his combine breaks down, no cell coverage. He's got to go back somewhere to call to get help. You can have an excavator that maybe his hydraulic pipes break. No cell coverage. He's got to take time to go get some assistance. So I know that aesthetically, the tower is not so appealing to a viewscape, but also on this piece of property are 3 transmission lines that I didn't see in your picture, but here is clearly a picture where the transmission lines, which to me are just as unaesthetic as the cell tower. But we do need the cell tower.
Anyone else in the audience? Any further questions for the board?
Can I clarify one thing?
Please.
And Mr. Chair, there was the hearing, as you mentioned, board member, as you mentioned, that things rolling downhill on you. And that was, our two previous BZA appeals that we discussed during the work session. We try to appeal before the November 4th hearing and say, hey, that's not a complete application. You guys made your determination, and so be it. It said, hey, those aren't appeals. We're not even going to do it. Well, this is an appeal. This is it. And that's why we really want you to look at that complete application. Because, when the idea that the zoning administrator can just say, well, 12 days or 11 days have passed, therefore it's complete. Whatever I give to the board, that's all they get. That is the Board of Supervisors of the Planning Commission. The goal of the zoning ordinance is that if they get the application, they actually review it, they can push it back to the applicant and say, no, we need more information here. We need it here, so that people are making an informed decision. Instead, applications are submitted. We don't think they're thoroughly vetted, and they're passed on. So you could have a really big application that's missing a lot of information. And that's our issue, is that when you look at these other sites, one of the main sites that they had considered, where they get for an alternative site, the timeline for it was in 2001. Then they have one from 2016 and one from 2014, and they don't give the details of why on that hierarchy, this is the only place it can work. And what's interesting is, if you did look at those public hearings that were before, a number of people stood up and said, my property can probably do it, mine can. It wasn't vetted. And that's the issue, is that if a cell tower is going up, that application should be full of, hey, look, we're sorry that this is going to be the worst case scenario for everybody, but we checked everywhere. And on 1, 2, 3, and 4, it just cannot work anywhere else. That was not in the application. And so part of it is, how do you know if you never asked, never checked? But guess what? They don't have to. If the zoning administrators just say, well, 12 days is deemed. I disagree. It's a legal difference between me and the other attorney, Mr. Taves, on whether or not the zoning ordinance should be looking at case law and ordinance about when it's deemed complete or not. The idea that the zoning administrator, it's deemed complete if he doesn't do his job, that may be the stakeholder, that may be what the position is, but you can say, hey, just so you know, Mr. Webb, what they submitted, that's not a complete application. Because he's allowed to ask them for more information. In fact, he's supposed to ask them, say, where is this? And he can actually go hire experts and say, you got to pay a little bit more money because I don't know about radio frequencies. And I need someone to come in and tell me that what you're saying is true. Because when you go through that application, it's just, some of it's just summaries, but it's all the information is not there. And that's what this is. In terms of undoing the action, we're just asking the board to say, is it complete? Because there is going to be a next time. And right now, hopefully through this action as well, that the zoning administrator is going to look at the applications and really vet them and say, wait a second, they haven't identified the other why it can't work anywhere else. They haven't gone through and given the detail of why you can't have a hidden structure. Or, as my client, Mr. Hammond, identified on the land that it's going to be on, MW Farm, the Willis, why it can't be pushed up the hill and hidden amongst the trees. Where's that analysis? That should be in this application. It's not. One wonders if the Planning Commission had that information, it would have been a better process. So again, part of this is going forward, but you can absolutely, we have a motion for you to sign as well, or you guys can make your own motion and simply say, hey, look, we disagree with the zoning administrator. We reversed the zoning administrator. It was not a complete application. And that's it. They may appeal it to the court. I doubt it. But one of the things that I'm very concerned about is that we appealed a determination about that application, and you guys don't have the application before you. It wasn't part of the materials. That should have been forwarded to you, and that is state code. That is ordinance, that when you appeal determination, the materials of that determination should be transmitted forthwith. and you guys should have that in front of you. If you don't, then I don't know how you also make a full decision if you don't have it to look at as well. So, I mean, if you don't have it, I think you should defer until you get the full materials of that application so you can make the decision. Thank you.
Any further questions for the board tonight? Hearing none. Y'all ready to vote?
Be ready to entertain a motion?
Yes.
Well, I'd like to say that I fully support whatever the Board of Supervisors and Planning Commission have done up to this point. And I'm relying on their abilities to follow through with the process, and I take it to mean that Mr. Webb had it correct, since that's what you're arguing with us about. So my motion is that your appeal be denied.
All in favor? Aye. That's unanimous. Motion carried.
Just to be clear, you're not entering that motion. You just simply move to deny and that's it, correct? Okay, thank you.
Suzanne, do you have this one?
Yeah, we're.
Yep.
Yes. I'm sorry. Yes, sir. You need a motion for adjournment?
Any other business to be brought before the board tonight?
I move we be adjourned.
Second. Meeting is adjourned.